Hello there. My name is Juan Kidane. I'm a professor of law at the Villanova University School of Law in Pennsylvania. I'm also a co-founder and partner at the Addis Law Group. That's an arbitration law firm based in Washington, D.C., Addis Ababa, and Dubai. We specialize in investor state and commercial arbitration. Some of you might have read my book. The most interesting one is The Culture of International Arbitration, published by OUP 2017. The most recent one is a more comprehensive treatment of Africa's international investment law, published in 2024 by OUP again. I'm absolutely honored to be a part of this year's program on international commercial and investment arbitration by the Institute of African Women in Law. I am recording this from The Hague, where I am for an investor state case at the Permanent Court of Arbitration. I'd have loved to be in Nairobi with you, but unfortunately, because of conflict, I couldn't be there. In the time that is allocated for me, I'd like to do two things. First, I'd like to introduce you, at least for those of you not introduced to it before, the system of international investment arbitration. The topic that I've been given is the African investment arbitration market. So because of that, the second part of my talk is going to be about the market, who participates in it, who has been participating in it, and who should be participating in it in the future. So let me begin with a very brief introduction to the foundations of the legal regime. I often like to start with the idea of the legalization of North and South relations. The real or perceived inadequacy of the domestic legal regimes for international investment has prompted the introduction of external legal standards and the outsourcing of dispute settlement outside of Africa. The notion is simple. If the courts are not adequate to address the needs of foreign investors, and the laws are also perceived not to be adequate, what happens? New substantive laws are crafted, and the dispute settlement process is also exported. That's what happens in investor-state arbitration. That's why almost all, invariably, investor-state arbitration matters take place either in Washington or in The Hague or some other major capitals in the Western world. What do the substantive rules do? They actually include principles such as rules against expropriation, fair and equitable treatment, these types of principles. They are extraneous or external to the domestic legal system. And they also include a waiver of sovereign immunity for those of you who follow these notions, meaning that the state itself cannot claim immunity and could be subject to a lawsuit or an arbitration in a different country. There's also the idea of the enforceability of the award in many different countries, whether it's through the Exit Convention or the New York Convention. Most people are more familiar with the New York Convention. That is how the system operates. Africa struggled through the system. Because of that, there is an increasing demand for reform. I will not get into the details of that. Let me now turn to the market for lawyers. I have conducted an extensive study about African cases that were arbitrated in Washington under the Exit Convention since the 1960s. I've selected a sample of about 30 cases. In all of these 30 cases, African states, or at least one African state, is the respondent state. I'd like to describe the anatomy of these cases and then talk about the market. As of 2022, there have been 180 cases that have been filed against African states. By now, I think that number is about 200. These are a combination of exit and ancestral cases. And by my own reckoning, I've done the statistics, approximately 88 arbitrators decided these 144 cases. No, the 30 cases, the sample that I have taken. And of the 88 arbitrators, 80 of them were from Australia, Canada, France, New Zealand, United States, United Kingdom. There were only 4 African arbitrators from among the 88. And more relevantly to this gathering, there were only 4 women arbitrators. There was no single tribunal chaired by an African. There was only 1 tribunal chaired by a woman. So there is a significant deficit in diversity in the system. That also obviously provides opportunity for African lawyers going forward. Going off the sample which I just described, each case presents multiple opportunities for African lawyers. Assuming the lowest number of lawyers who could participate in either side, I could just give you an example. Now, for the case that I'm handling right now, my group of lawyers is about 12. So I'm taking a very small number of lawyers. Let's say each case participates 5 lawyers on each side. That is 10 lawyers at a minimum, right? So if we have 200 cases, for example, it actually offers opportunities for at least 2,000 lawyers. As I said, who were those lawyers in the past, in the last 40, 50, 60 years? Almost exclusively, with some very few exceptions, are lawyers based in the major capitals, Washington, D.C., New York, London, Paris. So let's talk about the next 200 cases. The number of cases is increasing every year, right? So we're talking about opportunities for at least 2,000 lawyers. And that's not limited to lawyers who participate on either side, right? 200 cases will provide opportunities for at least 600 arbitral appointments. As I said earlier, out of 88, we only had 4 African participants, right? And each arbitrator would have their own assistants. These are young lawyers who learn from them. If you have 200 cases, there's 600 opportunities for them. And there's 200 tribunal secretaries, 400 expert witnesses, 400 paralegals at a minimum, and some IT specialists, right? So this is a huge economic opportunity. Not only that, it is actually an excellent opportunity to learn. These numbers are extremely conservative, and in real life, the numbers are higher. So we have the market. And why do African states hesitate to appoint African lawyers? It's a rather complex question. I've been a part of this for more than 24 years. And I have some understanding of the dilemma, the conundrum. First, let's talk about who the claimants appoint. And then I'll describe the dilemma that the African states face when they are confronted with these kinds of claims. The claimants are often foreign companies. They have their own in-house counsel, their own connections with the lawyers in their own jurisdiction. So it's not surprising that a claimant from the Netherlands would actually hire Dutch lawyers, or a claimant from New York would actually hire New York lawyers. That's not surprising. Moreover, some of these major firms have offices across the world and recruit some of the best lawyers. So for the claimants, there's not a lot of dilemma. The respondent, however, the respondent state is confronted with a very serious dilemma. Why is that? The first choice of lawyers is made by the claimant, and the first choice of the arbitrator is also made by the claimant. That basically defines the center of gravity. Moreover, many of these investment treaties provide for default appointment provisions. Many of you lawyers would know this. The chair of the tribunal essentially decides the case. So if, for example, the treaty says that the Permanent Court of Arbitration appoints the chair, and the appointment of this chair is already dictated by who's appointed by the claimants. It has to be someone that fits that kind of requirement or criteria. The respondent state then needs to decide who to appoint as counsel and who to appoint as an arbitrator. The Minister of Justice or the Minister of Foreign Affairs, whoever is hiring, or the Attorney General, would have to think about who is the best person to represent the state under these constraints. So it's not always easy to make those choices. And let me add one factor. This is what I always say. Arbitration is 50% law and 50% sociology or culture. It's not enough that you have lawyers who are excellent, who have studied the rules of the game. You need also have some connection to the world of arbitration. You need to understand who the lawyers are. You need to understand who the arbitrators are. So there is the social capital that needs to be built. There's the law, and there is the culture and sociology of it. There's the structural constraints. That is the conundrum that African states face. It's under those constraints that they have to actually appoint lawyers. There are certain expectations. Professional competence is the minimum. It's the starting point. There's no substitute for it. Without having the technical competence, one cannot aspire to be appointed as counsel or arbitrator. Developing the social capital takes time through professional connections, such as attending conferences like these, making presentations, publishing papers. Those are the expectations, right? And it also includes engaging with governments very carefully and constructively. It's not helpful to always say, oh, the African states don't hire their own lawyer. There's a little bit of that, but it's a bit more complicated than that, right? One has to present herself, having the qualifications, the cultural competence, and all of the social capital needs to be built over an extended period of time. But once that has happened, it is happening, and we've seen it. There's no excuse not to be considering those lawyers for appointment in these kinds of cases. And of course, from a market standpoint, one has to constantly be monitoring developments in the field. Many of these arbitral proceedings are confidential. They're not even published. So when I say 200 cases, these are only cases that are published. I won't be surprised if the number is rather greater than that, significantly, maybe even double. So those are through connections, talking to government agencies, talking to claimants. That's what needs to happen. So what does the future look like? The future is almost inevitably a more diverse world where Africans are proportionately represented in every sphere of life. And that's what the trend shows. There is no doubt that African lawyers will be liberated from always being called local counsel and assume their rightful place next to their peers, befitting their competence and character. And that time is now. Let's work together, develop the competence and character, and engage the profession with some level of confidence and attempt to represent not only claimants in certain matters, but also African states. This is achievable. It's already happening. And I hope that the younger generation among the audience would actually take advantage of what's taking place around the world, and particularly in Africa, and present themselves very well, get all the degrees that they need to do, get the publications out, and participate more meaningfully in this very promising field, international investment arbitration. Thank you very much. I wish I could take some answers from you, but the constraints of distance would make that almost impossible. But I was very glad to have had the opportunity to present to you. Thank you very much. I hope to see some of you some other time. Goodbye now.